First off, I'd like to welcome everyone to the CMBA Bankruptcy and Commercial Law sections, Navigating a Chapter 13 through the Pandemic. We, as a organization, decided that we wanted to put something together for the local bar to kind of help them through this pandemic that the world's going through. And we thought that navigating a Chapter 13, with everything that's going on with the CARES Act and the stimulus checks and the changes in, not only our work lifestyle, but our personal lifestyle, that we thought it would be an appropriate subject to kind of address here in this presentation. We're kind of undergoing an, once in a lifetime experience as human beings globally that not only affects our work, but our day-to-day lives. And I know it's stressful for some people, and there's been a lot of changes in terms of how we operate, not just in the courts, but with everything. So we're hoping that this presentation here helps kind of guide you in navigating a Chapter 13 with the changes in the law, and obviously with the perspective of the 13 Trustees Office, from debtor's attorney firm perspective and a creditor's attorney firm perspective, and kind of help ease the transition as we kind of work our way through the pandemic. One thing to kind of keep in mind, and our presenters will probably address it as well, is that this is a constantly fluid, changing situation. So, between the time we decided to present this webinar and today, we've even tweaked a couple of things in how we approach things, and there's a good chance things will change. They change not only day to day with, restrictions and updates about the disease, but hourly. And I think we have to maintain that fluidity to be able to adapt to those changes. So first, I just want to introduce the speakers. My name is Milos Gvozdenovic. I'm an attorney with Weltman, Weinberg, and Reis, which is a creditors' rights firm. I work in their bankruptcy department. Our other presenters will be Phil Lamos with the Office of the Cleveland Chapter 13 Trustee, and Patrick Miller, who a debtor's attorney with Luftman, Heck & Associates. So I am going to pass the discussion off to Phil to start off with our first topic, which will be attending hearings remotely, procedures and tips. Thank you.
Okay, with the first pick in the 2020 draft, the Detroit Lions take Jeffrey Okudah, cornerback, Ohio State. Am I done? Okay, we are obviously in uncharted waters here, and the thing that Milos pointed out that I really want to emphasize here is the fluidity of the situation. We are all working essentially by the seat of our pants. We are trying to fix things as they come along. We are trying to anticipate needs. We are trying to solve problems before they appear. We are trying to solve problems on the fly while we keep moving. All of our programs that we have implemented at one point or another are not as they originally were intended to be. We have moved and changed as we go, while at the same time still trying to conduct business as normally as possible. And I do want to congratulate and thank everybody for their patience, for their hard work, and especially for their good cheer and disposition. Through things like telephonic exams and telephonic appearances and remote working, everybody has been pleasant and cheery, and it's very clear that everybody just wants to succeed and just wants to do what's best for their client and for the bankruptcy process as a whole. And I don't think we'd be able to be functioning as well as we are if everybody wasn't trying as hard as they could and going at this with a cheery and patient disposition. So if you are a regular practitioner, if you're an irregular practitioner, thank you very much. We would not be able to do this without you. So why don't we get started? We're going to try to do this in a kind of a time frame format. We're going to talk about immediate needs and then move on to longer term needs until eventually we get to even longer term needs. So the first and most pressing thing right now is with the courthouse being closed, how do we conduct hearings, both motion dockets and meetings of creditors? Right now, most everybody here is on the electronic filing anyway, so that really hasn't been too much of an issue with it not having access to the clerk's office. But we just, in a sense, take for granted the face-to-face interaction of meetings of creditors and motion dockets. So that was really one of the first things we had to overcome. Before the courthouse closed, we were able to conduct some recorded meetings of creditors at the courthouse. But now we are all conducting meetings of creditors from our various remote locations. What we are doing right now is we're conducting them all by telephone. I know there are other courts that make a video option available, but we here are sticking with the telephone option. We initiate the call here from the trustee's office. We call debtor's counsel, and we expect debtor's counsel to be able to conference in the debtors. Landlines are best, but obviously that's not an option for everybody. We've been working through some of the technical issues. Feedback actually turns out to be one of the more prevalent issues, but that's just sometimes just a matter of positioning. We've run into a handful of debtors' counsels who either can't or are unable to conference in their debtors. We will do that on a need basis. We'd like to avoid it whenever possible. But it is an option. If we do have to initiate the conference call here from the trustee's office, we ask debtors counsel to make sure the debtors know that we're going to be calling, because we have had at least one occasion where debtors refused to answer the phone because they didn't recognize the phone number from which the call was coming. So a little bit of prep work on the debtor's part. Debtor's counsel's part. Make sure your debtor is in a secure location. We've had debtors who have to be at work and they step aside and, they go to a private location. If they're at home, make sure they're in a place where they can take a phone call and be relatively uninterrupted. Nobody likes to hear a dog in the background or a baby or a television or whatever. We still need to verify a debtor's identity and social security number. And we've been doing that by requiring the debtors to get copies of their identification to debtors counsel in advance of the hearing. And we leave how that happens up to debtors counsel, whether it's a photocopy sent to the debtor or whether they come in and whatever their office is and make a copy there. But then we ask debtors counsel to attest on the record that they have verified the debtor's identity and social security number. Debtors counsels are officers of the court. Their word is as good on the record as anything else. Debtors counsel, we assume, have had sufficient interactions with the debtors that they can verify their identity. They know the requirements for verification of identity and for verification of social security number. And we ask that to be done on the record as part of the meeting of creditors. Now, ordinarily at the meeting of creditors, we also ask the debtors to verify it's their signature on the bankruptcy petition. Obviously, we can't do that now. So what we've been doing is we've been asking the debtors if they signed the bankruptcy petition, and that seems to be sufficient for the time being. Now, all of these practices have been approved by the U.S. Trustee's Office. I don't know what they're doing in Chapter 7 hearings. I have to assume it's something relatively similar to this, but this is how we've been doing it with the Chapter 13s for the last month or so. Pat, as a debtor's counsel, how is it working with the telephonic meetings of creditors on your end?
Thanks, Phil. You're right. In a lot of the points that you bring up, I think a lot of it comes down to preparation. I liken this to being not much different than preparing them for an in-person interview. You just have to make sure that they understand the logistics. There's a lot of unknowns on the client side for any of these hearings. Really what I have been finding is most important is for them to have an understanding of the logistics. Phil's right. There's nothing worse than having a dog that's interrupting the proceeding, or, you know, if it's a small child, I mean, everybody seems to understand, but the trustees are trying to manage their docket. The telephonics seem to take a little bit longer logistically. That's no condemnation on the trustees. It's just the logistics of it. So it's important that as debtors counsel, you're going over exactly what to expect with the client ahead of time. Typically, I try to get people on landlines, but it's 2020. There's not a lot of people on landlines anymore. So having a brief discussion, you know, is there a place in your house or at your work where you don't get great reception? Well, try not to be moving around. Try to be sitting in a stationary space. The other thing that I think is important to go over that I think is missed by a lot of clients is they liken it to, sometimes they might liken it to no different than a normal telephone conversation. They might get lulled into that. So having some way for them to have a recognition that this is a really important court hearing where their answers are being recorded and their answers are important to be accurate. It's important for them to limit distractions. I encourage them to, you know, possibly find one specific spot in their house and just sit there. And then, you know, as a trick, I tell them, you know, you could pull up a picture on your laptop that shows a picture of a judge, just so you know it's important. It sounds silly, but I've had people get into more of a conversational nature with the trustees and kind of lose track of the fact that they're supposed to stay on point and just answer the questions, and just something to create that atmosphere of it being an important court. A court-attended hearing is very important for them. The other thing that I try to make sure that they're aware of ahead of time is their specific trustee. Phil's kind of laid out the way that his office is running the 341s. It's not much different from trustee to trustee, and on the 7 side, it seems like they're all employing a similar method, but it's important to know your individual trustee. If they have specific documentation that they're requesting ahead of time, make sure you're getting it to the trustee ahead of time. And then in terms of the signature documents, I typically send a copy of page 6, the ECF declaration, and a copy of, on the 7 side, a copy of the trustee's notice. It's just something to have in the client's hands, so if they are asking to attest to those documents being signed, they can look at it honestly at the same time that the hearing is being conducted and admit that, yes, that is my signature. For the most part, I don't have too many clients that are having difficulty accessing emails, but even in those circumstances, you can just always photocopy the documents and send it out to them. The logistics on your own end are important as well. We're all conducting these hearings, maybe sometimes from an office, sometimes from our own private home. It's important to make sure that everybody in your own household, if you are there, or in your office space, understands that even though you're present, I actually, in my office, if I'm there, I could be interrupted on a regular basis unless I tell people ahead of time. Yes, it might look like I'm just on the phone on a normal matter, but it's an important hearing. I can't be interrupted. Same thing at home. I think going over those logistics with the people that are present ahead of time is important for yourself and your own professional stature, but also to make sure you're not interfering in your own clients' hearings.
From a creditor's perspective, obviously, we don't necessarily attend meeting of creditors that often, particularly even in Chapter 13s, even less. Coincidentally enough, I did, during this pandemic, I did have to attend a meeting of creditors remotely once. And I guess the biggest thing is, whether you're trustee or debtor's attorney, just so as long as there's availability for creditors to attend if they have to, and just to kind of mirror what Patrick said, is every trustee is different. So some do it telephonically, The one I attended was done via Zoom, similar to what we're doing here. The one that I attended, there was some kind of growing pains in the early stages because there wasn't any kind of public notice as to how it was going to be conducted. I think now a lot of the trustees, Phil, I believe you guys have a notice on your website with instructions. Is that correct?
It is, yes.
Okay. I've seen other trustees, at least early on, file notices with the court of cases that were filed pre-pandemic, but the hearing was conducted after. It says notice of telephonic hearing. You know, there's a lot of different ways to do it. The only advice that I'd give to anybody that needs to sit in on a meeting of creditors that's not an original party, not a debtor or the trustee, is that you probably want to reach out in advance. And I think Phil can chime in on this. They would appreciate it if you at least let them know that you plan on attending and work out the logistics of that. So there's not any kind of scramble or fumbling to do it the day of. So I'd probably go well in advance of a week to kind of start laying out the groundwork to make sure you can attend telephonically as well. And the same things apply for creditors' attorneys as they do for anybody else that participates. You know, there's the etiquette, mute your microphone, don't put on hold. I had another experience with one of the judges on their docket where somebody put their phone on a hold and the music was playing for everybody that was in the hearing. So it delayed the hearing by like 20 or 30 minutes. They made everybody hang up and call back in, and it happened again. So just make sure, it's always a good idea to work through the technology if you're not familiar with it before you jump into the hearing. And then just kind of turn it back to Phil. Phil, if a creditor does need to appear at a meeting of creditors, would you appreciate the call in advance to coordinate it? How do you guys normally like to handle that?
Well, we have had creditors appear at meetings of creditors telephonically. I believe at least one of them is actually listening in on this conversation right now, so that's good. A note ahead of time that they want to participate is the way to handle that. We can conference them in. One of the things that gets lost by not being over at the courthouse is the knowledge that you're in the right place. Debtors' attorneys know that, you know, they come to the 6th floor at the courthouse, they see the list that's posted, they realize that they're there for their meeting of creditors, and they know they're in the right place. They find their client, they talk to their client. We try to stay as close to being on schedule as possible, but that being said, if you've got, say, a 9:30 meeting of creditors, you might not get a call until 9:50 or 9:55. If you're worried that we don't know you're on the list, feel free to check in with us a day ahead of time. And the same goes for creditors too. If you're a creditor and you want to be included on the meeting of creditors, contact us a day or so ahead of time. What we do with debtors' attorneys is someone from our office has been contacting debtors' counsel either a day or 2 days ahead of time and making sure they know that they're on and that we have a number where they can be reached. Obviously, some people are no longer in their office. They give us a cell phone number where we can reach them. So if you're a debtor's counsel and you're afraid that you're not on for a meeting of creditors, if you've gotten one of those calls, clearly that's an indicator that we know your meeting is coming up. But if you're worried, feel free to call the office. Feel free to check in with us. Feel free to make sure that we know you're where you are and that we've got a cell phone number where you can be reached. It's been kind of a white knuckle ride at times because with the staffing levels that we are at right now, some of our responsibilities have been divvied up among other people. But we've been operating at a surprising level of accuracy with regard to making sure we know who's where they're supposed to be and how to reach them. I'd say we've been doing this for maybe 5 or 6 weeks. I bet we've only had 1 or 2 situations where somebody wasn't at a phone number where they said they were going to be, or we weren't able to get a hold of somebody. So again, that's a tribute to everybody who's been participating. They're accurate. They want to get this done. Everybody knows we're all in the same boat. So I think that that's worked fairly well.
All right. I think I was just looking at the Q&A. We don't have any specific questions about attending hearings remotely. If you guys don't have any additional information, I would say we move to the next subject, would be motions for moratorium.
Well, how about we talk for a minute about the telephonic motion dockets?
Okay, that works.
I mean, everybody I think knows at this point that all motion dockets are being conducted telephonically. At least I know for Judge Harris, every time a docket is published, the instructions on how to access the telephonic docket are on the front of the docket. The instructions are very thorough. It's a toll-free number. You call, there's an access code. The access code is printed on the front of the docket, and you're automatically connected. But you have to remember, you're connected in listen mode only. You're automatically muted unless you unmute your microphone, which is done through a specific command, which again is published on the first page of the docket. I will just make sure everybody knows to unmute their phone. We've had a couple of instances where people were believed to not be there, and it turned out that they were there. They just couldn't figure out how to unmute their phone. And if you can't unmute your phone, you're not there. That's the only way anybody can know whether you're actually present, is if you're able to unmute your phone and identify yourself on the record. Same situation. We've had people who unmute their phone at the very beginning, even though, you know, their name might not start with H or a letter. And then they're sitting there through the entire docket, and we hear everything that's going on their end, whether it's the telltale ping of an email, or coughing or ruffling in your seat, or some very inappropriate ringtones on a couple of occasions. So it's again, it comes back to what Pat talked about. It's logistics and understanding the technical aspects of it. Know how to make the call, know how to work your phone, know how to work the mute and the unmute, and you'll be fine. Everybody gets their day in court. And by doing this, we've actually been able to move a lot more cases toward confirmation and their ultimate disposition. And that's a good thing, because obviously it puts money in the creditor's hands, it puts money in debtor's counsel's hands, if we can get things as confirmed as quickly as possible. We're still open for business. So if you've got an unconfirmed case or a meeting of creditors, we are here. Call us. Let's work stuff out. I mean, let's get these cases confirmed as quickly as possible.
And I think that Phil brings up a good point there at the end, which is they're there to speak about your cases. I mean, the easiest way to avoid having to attend these hearings is just maybe reach out to the creditor or to the trustee's office ahead of time, see if there's some way you can resolve it. I'm sure that we're doing that on a regular practice anyway, but I understand right now, with everything that's going on, nobody has a vested interest in having these dockets go any longer than normal. And I'm sure the judge would appreciate, and the judges do appreciate, when we're able to work these things out without having to sit through a cattle call of a telephonic court appearance. In terms of the court hearings, everything Phil just said is what I've been witnessing as well. It's just on debtor's counsel. Just understand what the specific court rules that you're under, what those logistics are. If it's I think sometimes it's a *6, sometimes it's something different you have to hit. Just make sure you're ready to go at the time that your case is called, so that you're not creating a disruption for other people or even for yourself. I don't have anything else on the court dockets. I just would say one other practice that I'm doing with the 341s is I'll call my clients 15 minutes ahead of time, remind them of some of the things, do a normal prep as if I was sitting in the 341 waiting room with them. It helps put their nerves at ease, I think, a little bit. It also helps you refresh and make sure that logistically they're ready to go. And then it's not a bad idea to caution them that while things typically are fairly punctual on the 341 dockets, now it's a little bit different. And it's important for them to be patient with technology glitches. I've been on a phone with a trustee. They call the case, and it takes them 10 minutes to get the technology up and running because of some kind of a glitch. Well, you don't want your client complaining, make sure they're aware that they're as reasonable under the circumstances as you are being, and the trustee typically is being in those circumstances.
One thing that Phil said too, I just want to kind of focus on that as well, is as far as I know, almost all the judges in the districts that I practice in have on the court website under their memorandum or by their court docket instructions on how to attend telephonically. So the court website is a good resource to get that information, and make sure to read that, those instructions very carefully, because they may not be the same judge to judge. But they are available for public consumption, and you do need to take some time ahead of time to look into that and make sure you have that correct. So I will pass it back to Phil, and then if he's done on that subject or wants to address the remote hearings, if not, we'll move to the motions for moratorium.
Thank you. I would hope that every debtor's counsel is at least making some kind of a reach out to all of their clients at this point, making sure they're okay, making sure they understand what's available to them, what their options are. Obviously, the success of a Chapter 13 plan is based on debtors being invested in the plan and knowing what their responsibilities are and the benefits it provides to them. A plan, I mean, even 36 months is a long time, and it can be difficult to keep a debtor engaged, whether it's for 3 years or 5 years, once that initial relief that's granted to them from the petition tends to fade away into the background. I mean, they are dealing with foreclosures and repossessions and garnishments and all the stress that goes along with that. And when the bankruptcy is filed, they get that relief. The foreclosure is off the table. The repossession is no longer on the table. The garnishments stop. The phone calls stop. But as the bankruptcy progresses onward, that relief that they feel tends to fade into the background, and the bankruptcy becomes more of an obligation. It becomes just something that comes out of their pay, and it becomes something that inhibits them from doing what they feel like they want to do. So I think it's imperative on all debtors' counsel at a time like this to do a check-in on all of their clients. Make sure, are you still working? Are you incurring any extra expenses because of your, because of the pandemic? Are your children being stuck at home? Are you forced to take care of elderly relatives? Are you on furlough? Are you on partial work? Are you on layoff? Are you working overtime? Your clients are going to be nervous, and they're going to want to know that someone's looking out for them, and they're going to want to know what options they have available to them. And I think that comes to our next topic, and that would be coronavirus moratorium motions. For those individuals that are adversely affected by the current pandemic, we have making available, at least initially, a 3-month moratorium for all debtors who have been adversely affected by the coronavirus. There's a form motion. It's on our website. I don't know if it was distributed to all participants, but I know we made it available. It's basically a fill-in. You fill in the day you want the moratorium to start and the time you want the moratorium to end, 3 months. So for example, if you start your moratorium on May 1st, we would expect it to end on August 1st. That's 3 months. We are expecting you in the motion to state the reason or how you've been adversely affected by the pandemic, whether it's that you're on reduced hours or that you're laid off, or that your significant, your domestic partner has been laid off, or there's been some kind of extraordinary expenses that have been incurred, something so that it's put on the record exactly how the pandemic has left you unable, or your client unable, to make the regular payments. Bankruptcy payments, Chapter 13 payments under this agreed form moratorium can be suspended in their entirety, or they can be reduced. If you have a conduit plan and you would like to keep making the the conduit mortgage payments. That's available to you. In the form motion, we're asking that you designate whether the plan is a conduit plan in which an ongoing mortgage payment is being made, or a non-conduit plan in which no ongoing mortgage payment is being made. And we're asking you to state whether you want the conduit payments to continue or whether you want the conduit payments to stop. Now, we're making no representations as to how the cessation of any ongoing conduit mortgage payment would be dealt with by the mortgage company. I know mortgage companies have plans in place for, coronavirus relief. That's up to a dealing between you as debtors counsel and the mortgage company itself. We have had a few mortgage companies come in and ask that their rights be protected in the case where conduit mortgage payments are not being made. Whether those mortgage payments are dealt with at the end of the mortgage or made up through the plan, that's a matter between the debtor and the creditor. And we also have a form agreed order for the granting of this coronavirus moratorium as well. And the courts have allowed the entry of this agreed order without a hearing, as long as creditors are given 7 days to respond. So if you were to file a motion today on the 4th, what we would ask is that you let us know here at the office, either Holly Davala or myself, depending on the judge, via email, that the motion's been filed. We'll take a look at it. We'll either say it's okay, or we'll say that there's some issue with it. Sometimes the problems are that there's no designation as to whether it's a conduit plan or not. Sometimes the folks have counted the math wrong on how long they're asking for, so we've asked for some corrections on that. But once we indicate that we're okay with the moratorium, we'll indicate that via email that you can affix our electronic signature. And once you submit it over the court will hold it for 7 days and then enter that agreed order if nobody opposes it. So you can get a moratorium without even having it set for a hearing 7 days after you've submitted that order to the court. Now, the moratorium and the agreed order will stop any wage order that's currently in place. So if you are asking for the plan payment to only be lowered because you're going to make the conduit payment during the moratorium, well, that wage order is going to be stopped. So it's going to be up to your clients to make the payments in that lower amount directly to the Chapter 13 trustee for the duration of the moratorium. We're hoping that 3 months provides enough time. Obviously, this is where the fluidity comes into place. We are not opposing or refusing to sign these coronavirus moratorium because a plan is infeasible, but that is a problem that's going to have to be dealt with later on, which I think we'll get into a little bit later when we talk about motions to modify. But it is an issue you are going to have to consider when seeking the moratorium. Now, again, the fluidity comes into place. The earliest of these moratoriums are going to end in the end of June. If we don't hear from you when the moratorium ends, we're just going to assume that your client is back to work and that they no longer need the moratorium. And right now, we're probably going to just go ahead and put the wage order back on. So if you're, sometime before the end of the moratorium, we're going to expect you to check in with your client. Are you still off work? Do you still need another moratorium? And we're going to ask that if your client is still off work, it's going to be imperative on you as debtors counsel to make sure you take the affirmative actions to make sure that that moratorium continues, probably through the filing of another motion for a moratorium.
Phil, we have a question real quick, kind of going back to a minute ago. The question was, do you have to serve creditors with the motion for moratorium?
That's a very good question. And the court has allowed that service through the court's electronic service is sufficient So any creditor who gets electronic service and would be served automatically through the filing of the motion, that constitutes sufficient service. I hope that answers the question.
Yeah, if somebody has a follow-up question or if that didn't answer the question, feel free to put that in the Q&A. We'll circle back. Otherwise, Phil, you can keep going forward on that.
The courts have asked us to make sure that anybody seeking one of these form moratoriums, at least with Judge Harris, to not set it for a hearing. File the motion. If you read over the motion, it deals with service and it deals with the negative notice provisions and how those work. But if you set it for a hearing, the courts have to track it for that hearing date. And obviously they have staffing issues as well. So they have specifically asked us, at least with Judge Harris, to make sure that it not be set for a hearing. We're committed to a pretty quick turnaround time. I'm generally get them turned around within 24 hours. So the important things are, if you file a motion for a moratorium, let us know it's filed and send us over a proposed agreed order, and we'll get it turned around fairly quickly. One thing I want to emphasize, though, is because of our current staffing and remote working issues right now, we are not refunding any monies that we receive during any moratorium granted. It's just it's too difficult right now. We don't have enough people in the same place for us to issue any kind of a refund on any reasonable turnaround time. And the language in both the motion and the agreed order specifically states that no money will be refunded. What we're trying to do is, by filing the motion and by getting the agreed order in so quickly, we're trying to get that wage deduction stopped as quickly as possible to prevent the need for any kind of refund going forward. So I do want to make sure we emphasize that if a coronavirus moratorium is sought and approved, there are no debtor refunds. Any money that we received during any granted moratorium will just be processed like any other payment. So let's make sure we get those orders granted. Follow up with the employers. If you have to print a copy of it and get it to the right person, do that. Make sure that the employers know as soon as possible not to make that deduction. If you've got a client who has an automatic pay, say for example, the money comes out through our ACH, contact our office. We've got people here who can make sure that that ACH is stopped if you have an approved moratorium. I'm going to throw it over to Pat now. Pat, can you talk about any kind of issues from a debtor side as to the moratoriums?
Sure, thanks, Phil. The number one thing that I've been seeing from the debtors is making sure that you're matching up their need with what is actually required. I've had a number of debtors. I think we all can put these people in categories at this point in time, where you have debtors that were calling you before there was anything and any type of an issue on their end, just anticipating that there was an issue. And then there were ones that maybe are waiting until I'm reaching out to them. I think Phil does provide a really good point of advice, which is reaching out to all of your Chapter 13 debtors right now is important. What I've actually been finding is surprising. There's actually a decent number of my clients where their employer, even if they're not working, is finding creative ways to provide them with funds, either through the PPP program that a lot of small businesses are doing, or through creative use of vacation time or an extra granting of personal and vacation time. And for those debtors, when you review that with them, you talk to them about how they can use that now, hopefully, to stem them over until everything abates. And then if it doesn't abate, we still have this moratorium option in the future. Making sure they're aware of that as an option, I think 90% of the times is really what's helping my clients just give them a peace of mind. One of the many hats that we wear as debtors counsel is as counselor, and sometimes, especially in an area and at a time that's fraught with a lot of uncertainty, such as we're in right now, the important thing to realize for them is that you are there for their questions. In terms of the moratoriums, when I am approaching that, trying to help them to understand the benefit of trying to keep a conduit payment going, even if they can't afford their entire payment, is important. If it's just not possible, if they've completely lost their job and they're only relying on unemployment, the unemployment is largely only going to help them with their necessary and reasonable expenses. It's not going to provide them with anything extra, even potentially a mortgage. But if they do have that ability, the nice thing about the moratorium and the motion for moratorium template that's been provided by Phil's office is it does give you the option of just reducing pay and providing where the conduit can still be paid by the client, providing a notice obviously to the mortgage company and an assurance to them so you're not battling unnecessary relief from stays in the future, that they're still going to get paid. And I think all of that is just about making sure that your client knows that that's an option. I think with the mortgage payments, if they are, asking that the mortgage payment also be delayed or deferred in some way, I've been advising them that under the CARES Act, and we might discuss this a little bit better under number 3, but under the CARES Act, the mortgage companies appear to be generally open to the granting of forbearances, but it seems to be something that's not necessarily just given voluntarily by the creditors, but it's something that has to be received as a request from your client. So in connection with a request for moratorium that they might be asking, I have been asking them to reach out if they do have a mortgage, to reach out to their mortgage company as well to see if there's any type of program that's available for a forbearance on their mortgage payment. I think that keeping everybody informed and that communication is tremendously important so that you're either not under asking for relief for your client or over asking for relief from your client. The next thing that Phil had addressed is one of the concerns that I have. Logistically, the trustees have largely indicated that return of funds would be something that would not be possible. So it's important that you are addressing the concern quickly with your client, but also once you do have that agreed order, is reaching out to their employer. That has its own unique aspect right now. I have had difficulty in a couple cases getting a hold of HR because, again, their HR department might be working remotely. Just be persistent is the best advice I can give you. What we're trying to avoid is any extra work across the board. I'm trying to make this as streamlined as possible by using the template of the motion for moratorium and then following up with the employer to make sure that they're doing what they're supposed to. It'll help, abate any kind of a need for you to file any types of motions for turnover from the trustee's office, or if they've already paid those and made those disbursements to the creditors, trying to get it from the creditors. It's just going to save you a lot of work for maybe just what would take maybe a phone call or an email up front to an HR payroll representative to make sure that it gets in the proper hands as quickly as possible. The feasibility issues that could be created by specifically a mortgage forbearance, I think we'll be addressing in the next part, but it's important for at least a brief conversation with the debtor at the time you're filing the motion for moratorium, making sure that they understand that they are going to possibly have other motions in the future that would have to be filed to correct any issues that come up. It's just better to set that expectation, I think, up front with your clients, that they understand that this might be addressing the issue on an immediate need right now, but if there is any follow-up, then they're going to be expected to do that as well. For the most part, my clients, even with the uncertainty that's out there, they've all been tremendously receptive to the offers for moratorium. And it's been my experience so far that the vast majority of them have been able to, again, get workouts with their employer, either through the PPP funds or additional personal time or vacation time that they might be receiving on an emergency basis, or even with their stimulus checks. We'll, again, address stimulus checks later on. They're not mandated to turn them over as disposable income, but some of my clients, even if they would have been eligible for a moratorium, and I've advised them of that, they're more than willing to use their stimulus funds to help stem the tide, as they believe that if they do need the relief in the future, it would still be available, through either the motion for moratorium that's presented or a standard motion. The other thing that Phil addressed that I think is an important point, I, at first, just like many of you, I was just mainly focused on the people that were losing their jobs. But I have had a number of clients that, as I've been going through my active 13 cases, not only are they not affected negatively by the coronavirus, in some areas, in some sectors, they're actually potentially doing better than they would have. Usually offers of overtime, specifically are medical care professionals out there. It's not a bad idea to have that conversation with them, making sure that they understand if there is any type of responsibility to report what might not be just a minor uptick in their income, but a longer period of uptick during this time, that they really should be getting us that information as well, just for our own review, and if necessary to address that in their bankruptcy plan. Again, this is something that's more something that I'll be addressing later on, maybe in future motions to modify things of that nature, but it's going to be a difficult surprise for yourself and for your clients if, after the trustee reviews their income tax return for 2020, they realize that they were actually in a weird way benefited by the coronavirus with extra earnings. So I've been making sure I'm keeping track on those clients as well. There's no reason not to be proactive on that, to help yourself out and them in the future, to make sure that their plan goes by seamlessly and they're not facing motions to dismiss in the future.
Yeah, from a
Go
creditor's,
ahead, Milos.
I'm sorry. From a creditor's standpoint, I don't necessarily think our approach with motions for moratorium has changed much. It's a very rare situation where I would recommend to a client to object to a motion for moratorium. Usually they're short-term, 2-3 months, and I defer to the expertise of the trustee, that he's confident that if they don't object to the moratorium, that the plan will complete as agreed within the allotted time period. I did have one recently, a client reach out because they haven't received payments for a couple months, and I indicated to them that with the wave of the pandemic, these moratoriums now are they have a pandemic moratorium, and my general philosophy is not to object anyways, but particularly now with the pandemic, if the actual cause of the request for the moratorium is pandemic related, I don't think, for multiple reasons, it would be a good idea for the client or creditor to object. The other thing is just the overlying theme of this motion for moratorium that Phil touched on and Patrick touched on is you want to be proactive, not reactive. Because the issue is, don't wait until your plan's 3-4 months behind, and then, the trustee files a motion to dismiss, or we file a motion for relief, and then come back and try to do a retroactive moratorium. I think it's beneficial to all parties if you can catch that sooner. Because the issue that I've encountered is the debtor falls behind on the plan payments. I don't have any other recourse than to file a motion for relief. And then the debtor may scramble to file a motion for moratorium claiming it was a COVID issue. But, I think it should have been addressed sooner rather than later. On the same note, and this is probably more touched on in the next section, is, take what you need. If your client needs 2 or 3 months, and I think even Patrick mentioned as a debtor's attorney, it's to his client's best interest, only take 2 or 3 months. If you don't need the 4 or 5 month moratorium, I don't see the benefit to anybody by taking it if you don't need it. And then as for the forbearance, and we'll touch on that more, but since it was already touched on a little bit here, all I can say is I think almost all of my clients have some sort of process to review these. I'm still kind of getting a feel for who handles what, how, but I think your first step would be if there's an attorney that entered an appearance on behalf of a creditor and you're looking for some sort of a forbearance. I think I can speak for myself. You could reach out to my office. If I can't handle it for you directly, I'll reach out to my client contact, and they'll at the very least be able to provide you with a proper department and phone number for you to request that forbearance. That's all I had to touch on that subject.
Milos brings up a good point, something I want to talk about. Because there are so many options available to debtors and debtors counsel who are experiencing coronavirus issues, we're assuming that if you don't take advantage of those options, whether they be moratorium or forbearances or whatever, that your clients are not affected. And, you know, we're not assuming that everybody, all of our debtors are having pandemic issues. So if your client falls behind in payments and there's no motion for moratorium sought, there's no forbearance issues, there's no contact from debtors counsel, there's nothing that's stopping us from filing a motion to dismiss. And then you would have to come in and file a response. And by that point, now you're on the defensive. You have to come in and say, oh, my client was laid off due to the pandemic. And you can avoid that by being proactive. You can avoid that by contacting your clients in advance and finding out where they stand and getting yourself a moratorium when it's appropriate and taking care of those problems right at the inception. What I tell debtors at every meeting of creditors is small problems turn into big problems and big problems turn into insurmountable problems if you don't get ahead of them. And the same thing goes here. If we don't hear from you, whether it's through a phone call or through one of our form motions, we're just going to assume that you're not affected by the pandemic and there's nothing that's going to stop us from seeking whatever legal remedy might be appropriate. So, I mean, they're easy to use, they're pretty self-explanatory. Take advantage of them if you need them. And we can talk more about, you know, the appropriate remedy as we go. And I'll leave it to Milos now if we want to move into another topic.
Sure. We will now move into the third topic, which would be the CARES Act, plan modifications, and mortgage issues. So, Phil, if you want to go ahead on that as well.
Sorry, couldn't find the mute button. We're okay now. Obviously, the CARES Act has come into place and it provides specific relief for bankruptcy and debtors. A couple things I want to talk about. Before we get into the motions for moratorium, I want to just make a couple references to stimulus checks. Even before CARES Act came out, we made a decision here in our office that we weren't going to seek turnover of stimulus checks. You know, those checks were issued for a very specific reason. They were issued to help debtors get through a very difficult time. They were issued, you know, to help stimulate the economy in some ways. And we made a very specific decision not to interfere with those stimulus checks. That's been reinforced by both the United States Trustee, and it's also been reinforced by the CARES Act, which makes specific statements that stimulus money is not to be treated as disposable income. So, you know, with regard to stimulus money, we did get a handful of phone calls when the CARES Act first came out and when the stimulus checks were first announced. We did not seek turnover of any stimulus check. We were not treating them as disposable income, and we're not expecting them to be turned over. What we are expecting, though, is when you do your declaration of income every year, we are expecting those stimulus checks and the receipt of those stimulus checks to be disclosed. You know, Chapter 13 debtors, under certain circumstances here, each year will ask for a declaration of income, and it asks for any changes in your income. Have you, we're comparing it to your schedules, inheritances, gambling winnings, windfalls, settlements, that kind of thing. We are expecting stimulus checks to be disclosed on the declaration of income. But the CARES Act is very specific with regard to treating that as disposable income. I cannot envision a scenario where we would seek the inclusion of that in any kind of a capture, whether through a dividend or anything like that, but we do think it's appropriate to disclose it. Real quick, Pat, have you had any dealings with stimulus checks and their impact on a bankruptcy?
In the Chapter 13 realm, again, I've been encouraging my clients to be prudent with them. I've advised them of the declaration of income, that they're still going to have to report that. For the most part, the clients on the 13 side, I think, get it. They're already in a position where they have been, hopefully, in an arena where they've been forced to budget their money. So the stimulus checks, if they're still employed, they're using it as sort of a cushion in case there is any kind of reduction in hours to help supplement their household expenses if they are still continuing to make their Chapter 13 plan payments. On the 7 side, there was a little bit more, I think, nervousness on that, but it's fully protected under the CARES Act. Our own state exemption is the A12D. I believe that provides for any kind of support or loss of wages exemption. So it's not really something that's coming up anymore. More of just a question that the clients are asking to make sure that they're not running into any kind of issues. I had one client, I think, that was was planning on submitting the payment on their Chapter 13. Again, I encouraged them, unless it was something to supplement payment that was being missed, is better used for their own, to cushion any kind of unexpected expenses that come up going forward. Again, in that specific case, her pay wasn't being interrupted in any way. And she felt, well, hey, it might be an opportunity for me to pay more into the case. Again, I would treat that as any other type of lump sum that they would be receiving in a case, with the exception of understanding it's not to be treated as disposable income. Other than that, not too many questions about the stimulus funds. I think they did a good job. The legislature did a good job of making sure that it was funds that were used for that purpose of helping out the missing income that people might be having.
Yeah, from a creditor's standpoint, obviously we have no horse in this race, so to speak. Usually an issue with the debtor and their attorney and potentially the trustee's office, but like I said, we have no opinion or involvement on those, so nothing to comment on the stimulus checks. And
then why don't we talk about the most speculative part of the CARES Act, at least as it relates to bankruptcy, and that's motions to modify the Chapter 13 plan. The CARES Act provides that a plan can be modified to stretch the length out to as long as 84 months. Now, that's only under a couple of specific provisions, and I want to get into those provisions right now. Under the CARES Act, you can modify a plan to stretch it out to 84 months only if it's already been confirmed. So you can't propose an 84-month plan right out of the gate, and you can't seek to modify a plan to stretch it out to 84 months if it hasn't already been confirmed. We've already had a couple of instances where individuals have proposed 84 months plans right out of the gate, and we've had individuals who have proposed 84 months plans on unconfirmed cases. And at least according to the CARES Act, that is simply inappropriate. You have to be in a confirmed Chapter 13 plan. And also, you have to have been somehow impacted by the current pandemic. You can't just be using this CARES Act modification to cure an infeasibility problem caused by a greater than expected mortgage arrearage claim or a post-petition tax claim. These are only for debtors who have experienced some kind of an impact from the coronavirus. So you have to meet both of those criteria. You have to be in a confirmed case, and you have to be impacted in some way by the coronavirus. So when this initially came down, my first reaction was, geez, 84 months, that's outrageous. Most of these people are only going to be off work 3 months at the most. Why would you need to take an extra 24 months to cure a 3-month problem? And to that end, we are expecting and we are hoping that the courts go along with our belief that the relief that you're seeking should be tailored to the injury that you've incurred. If you can make up those missed payments in a 3-month window, we think it's in your best interest to do so. You minimize your cost. You're in the bankruptcy, obviously only the shortest period of time, which is absolutely necessary. Your client's money is not under the jurisdiction of the bankruptcy court for as long a period of time. Obviously in 95% of the cases, it's in a debtor's best interest to be out of the bankruptcy as soon as they possibly can. If you need that extra time, then by all means take it, but don't take any more than you absolutely need. And so I was a little taken aback that they would allow a plan to be stretched out for 84 months for a debtor who is only off work for 3 months. But then I thought about it a little more, and I saw where there are certain circumstances where, giving a debtor an extra 24 months might be beneficial. And it's a situation where a debtor misses some mortgage payments. If a debtor winds up in some kind of a forbearance and they're allowed to miss 2 or 3 payments, well, those mortgage payments aren't going to go away. I mean, they are going to have to be made up at some point, whether they're added to the end of the mortgage or the mortgage company wants some kind of arrangement whereby those payments are made up now. I know that there are some mortgage companies that I think were just initially demanding a balloon payment at the end of the moratorium. I don't think that's very prevalent anymore. What we have seen is some situations where mortgage companies have encouraged or negotiated for the debtors to make up those missed payments inside the bankruptcy. And there's a situation where you might need the full 24 months to make up for something that only lasted for 3. So, if you have a relatively low bankruptcy payment and your client is making the mortgage payments directly, and the mortgage payment might be relatively large, and suddenly they miss 3 mortgage payments, and through a negotiated settlement with the mortgage company, they agreed to pay those missed mortgage payments through the plan. Well, that might take an extra 24 months. And so there's a situation where I could see a debtor stretching out the plan to 84 months to make up for those missed mortgage payments. So there are some scenarios under the CARES Act where I could envision a debtor taking the full 84 months to cure their problems that were incurred through the pandemic. But we do want to make debtors aware that it's in their best interest to only take the smallest remedy that will cure their particular problem. A mortgage payment tacked on to the end of the mortgage, who knows what kind of interest that's going to occur. A mortgage payment that we were making that skipped, well, that could lead to a problem at the end of the case if they can't state that they're recurrent at the end of the bankruptcy. So only take the remedy, take the smallest remedy that is necessary to cure your particular problem. Pat, how has this impacted you from a debtor standpoint at this time?
Thanks, Phil. So the first thing about the mortgage forbearances that I'm seeing out there is that there's a lot of and it's starting to it seems as if it's getting funneled to a more straightforward approach. But at least initially, the lenders appeared to have different standards, and I think Milos talked to this to a certain point, where they had a different process depending on the lender in terms of how they were even processing these, and then how they were seeing it within the Chapter 13. As it's been going on, it seems as if they've been less inclined to force or request the immediate payback. Again, I think based upon what Phil had said, I don't think it's practical immediately after a moratorium period for there to be an immediate payback on this. I think that the number one thing I'd recommend on all of these issues is make sure you're communicating, reaching out to the mortgage company. I'm sure many of you out there have been noticing on your Chapter 13 cases, I think I've had about 5 or 6 of these where notices of forbearances have been filed by the mortgage company directly. And if you read those carefully, the majority of them are just notifying, just what it sounds like, just notifying the court of the forbearance and the recognition of it, but there's no statement truly as to how they're planning on handling that. Well, that's where you have to step in, make sure you're reaching out to creditors' counsel, see what the creditor is okay with. I'm preferring for my clients, and this may be just a personal taste on my end, for there to be supplemental proof of claims filed by the mortgage company. my clients have, in some cases, have resisted that and are more inclined to have it placed at the end of the mortgage. But my own experience in consumer law is if there's a way to remedy this and have a final answer in this case, I'd rather have them leave the Chapter 13 with a certain amount of definity going forward in terms of how that mortgage is being handled. So they're not surprised maybe by a balloon payment at the very end of their mortgage and everything emerges from the bankruptcy. I think it would also help with notices of final cure, where the trustee is paying the conduit, or if you file that on your own in cases where your clients are paying directly. It just helps to clarify everything and make sure that your client is moving forward, and not 20, 30 years down the line realizing, oh wait, that COVID crisis that I requested a 3-year moratorium on, now I have to catch it up now. That's where I think Phil's correct. That 3-month moratorium, if you are then curing that with a supplemental proof of claim, and if your client is open to that and the creditor is as well, that might take you into a case specifically in low dividend conduit plans where you might have to take advantage of the up to 84-month modification of the applicable commitment period. So I think that in those cases, I'm identifying them or trying to identify them proactively and identify those clients I know for sure that A, might have been affected by the coronavirus, and second, that are low dividend conduit payment plan. And those are the people definitely I reached out to the first week. And again, I had a redo about a week ago with them just to check in, see how they're doing, to make sure that if there is anything that needs to get filed on a modification level, that I'm doing that. I have cautioned, I have had a couple clients who have indicated, well, can I just extend this out? And they don't really have the need, or maybe they can nod to having the need, but I always caution them, if there's a way for them to complete the plan right now and there's not truly a need for the modification, it's A, not going to be approved, but B, is it really prudent and in their best interest for them to be under the court's thumb for another couple of years just because they saw that it was out in the news that it's possible for them. So that's another thing that I'm addressing with some clients. The feasibility issue, I think that the trustees, Phil's office, I've spoken with some of the other local trustees as well in their offices. I think largely they're going to be hesitating to file motions to dismiss for feasibility without at least reaching out to you first to acknowledge, especially if they see it's from something from the COVID matter. And the rationale on their end is less work for them, obviously, on the motion to dismiss, but also if it's just a matter of you filing the motion to modify and the parties can agree with that, it's usually the best route to go. The other thing that I would encourage, again, on the communication side is reach out to the mortgage companies, have your clients reach out to them proactively to request a forbearance if it's needed on the conduit mortgages, but also reach out to the attorneys as quickly as possible if you do see either a notice of forbearance or just who the attorney is from a prior notice of appearance in the case. I know that there's some creditors' attorneys, as I'm looking at the participant list here, that I've actually spoken to on this matter who your client isn't really sure exactly what they want to do. Well, it's still good on the debtor side for you to at least know that ahead of time so that and have maybe some ideas you could present to the creditors and creditors counsel in terms of how your client might be able to address any missing payments.
Yeah, from a creditor's aspect, I'll start with the forbearance first. Those are starting to trickle in now. I just had one recently from a client. They were asking us a similar request to file a notice of forbearance. And one of the things that Patrick said that I kind of side with is I think my approach has been on those situations, instead of filing the notice of forbearance, is to reach out to debtor's attorney directly first and provide them with a copy of the forbearance letter or the forbearance proposal. A couple of things, my personal thoughts on it are, one, I don't know if that debtor actually communicated with their attorney. They might have seen something or gotten a letter from the lender, and they said, well, let me feel this out. And reached out to lender. Lender said, sure, great. And they were working everything behind the scenes, but debtors counsel was never aware of it. I don't want to, blindside that person and file a notice of forbearance, and they had no clue that their client was discussing this with the mortgage company. The other thing too is I think as a creditor's attorney, and this mirrors a lot of how I approach loan modifications. I think there's potential plan ramifications or their associated documents or even potential modifications or moratoriums that would probably have to be filed in addition to that notice of forbearance. So I'm reluctant to just throw that out there and kind of leave it hanging without giving the debtor the opportunity to file what he thinks is appropriate. I almost look at it, it's not my position to try to figure out how this fits in with the debtor's plan. I think it's the debtor and the debtor's attorney need to figure that out. I'm just kind of a vessel to say, listen, here's what they agreed to do. Now you decide strategically what's best for your client on what needs to be filed and how that needs to be coordinated with the plan and the moratorium. And I don't know if you agree with that, Patrick.
Yeah, I do. And I've actually had a situation, it just came up less than a week ago, where I was working from home and the electronic relay came through with a notice of forbearance on a case. And as soon as I saw the case number, I immediately checked the bankruptcy detail and then checked my notes. And I literally talked to the client 2 or 3 days before where they had indicated that there was no interruption in pay. They were doing fine through the coronavirus, and it was just a really nice chat that we had had. So I was really surprised to see the notice of forbearance come down. So I called the client up, and the client said, "Oh yeah, I requested that just because I saw it in the news, and I just told the mortgage company, but I don't need that. I'm sending in the payments." So having those conversations with your clients up front, and you can't stop, unfortunately, sometimes a client from going rogue like that and maybe doing something that you're not aware of. And, if that happens, you don't want to get blindsided with a notice of forbearance on a situation like that. Now you're in a situation where maybe the mortgage company is thinking that there is a need there, and everybody's thinking along those lines. And then what happens in the event that the client continues to send payments, and how is that going to be addressed? The other point on that is, debtors are in the best position to craft their relief at this point in time. And if they are, asking and requesting for these forbearances, the assumption right off the bat is that they need it. But the other assumption is that they have an understanding of exactly how it works. And I think that that's where, a lot of our clients need to be educated that a forbearance doesn't mean that it goes away. And I think that that's the number one conversation when I have been finding clients and debtors that need that type of relief, that they don't quite understand what a forbearance truly is. So don't gloss over the term. Make sure that they understand that a forbearance doesn't, mean that they're getting a gift from their mortgage company. They're getting just a temporary, sometimes just a temporary delay in those payments, and going over that, making sure they understand and understand their commitment helps them understand which relief they can seek and what their actual, what their responsibilities are.
Yeah, and just to kind of go back on forbearance, if your client's looking for forbearance and they don't know where to start, I think if the creditor has a counsel of record, reaching out to them, like I said, if they can't help you directly, a lot of times it has nothing to do with their bankruptcy department. At the very least, they should be able to get you, hopefully, a number of or a correct contact at the lender to kind of work through that forbearance. And then once that's finalized, it would come back to the bankruptcy realm. Another thing, actually real quick, we do have a question, but it's related to stimulus checks. So since we got the momentum going with the forbearance, I'm going to circle back on that at the end. The other thing is I just kind of agree with Bill and Patrick in terms of, if you're looking to do a plan modification, don't be greedy, take what you need. I think the general theme here is, the trustee's office and the creditors and debtors attorneys have all kind of gotten together, and we're trying to streamline this process to help relieve people's financial burdens associated with this pandemic. So, I guess all we would ask in return is for people not to abuse that and take advantage of it when they don't need it. And I think that general theme seems to be kind of running through this subject of the CARES Act plan modification and mortgage issues. Just because you can go 7 years on a plan doesn't necessarily mean it's in your client's best interest, or that you can do it without any kind of scrutiny or objection. The other thing too is other things still come into play. So if your client's asking for a moratorium or a plan modification, you're probably not going to draw objections. No one's going to file a motion for relief. But please make sure that they understand they still have to ensure their collateral and all the other issues that they normally have to comply with. They still have to comply with, outside of the moratoriums and any kind of adjustments in plan funding. So that's all I really had to kind of add to this discussion with the plan modifications.
If I could jump in for a minute, I want to talk about something that Pat hit on when he talked about the supplemental proofs of claim. And it really, there's two different situations. There's the situation where a mortgage payment is being made through the trustee's office, and a mortgage payment that's being made directly by the debtor. Now, if the debtor is making the mortgage payments directly, and there's a forbearance and there's some missed mortgage payments, then it is appropriate for the mortgage company to file a proof of claim for those missed mortgage payments. But if the mortgage payment is being made through the plan and there's a moratorium and those mortgage payments are missed, and I don't want to get too technical here, but it's probably not in the mortgage company's best interest to file a supplemental proof of claim. It's really in the mortgage company's best interest to allow our office to simply treat those missed mortgage payments as missed mortgage payments and allow our system to make them up through the normal course of business. Our system prioritizes mortgage payments above almost everything else, and it will make up those mortgage payments almost, again, to the exclusion of everything else. So you would almost in all circumstances as a mortgage company do better allowing our system to make up those missed mortgage payments through our ordinary course of business than to file a supplemental proof of claim. So, again, that's technical and I don't want to get too deep into the weeds into it, but a mortgage company is almost always better off allowing our system to make up the missed payments through our ordinary processing than with the supplemental proof of claim. Now, that's only for mortgages that are being paid through the bankruptcy. Obviously, if a mortgage is being paid directly and there's missed payments, then the proof of claim is appropriate.
Yeah, I would agree with you there, Phil. I think at least our office generally has approached it that way. Usually, supplemental proof of claims are only under circumstances where there's a direct pay. I think we, between your office and all the other trustee offices in the Northern District, I think we have faith in the system working itself out as long as the money makes its way to the trustee as it's supposed to within the course of the plan.
Maybe that would be a good.
Oh, Phil, you just muted yourself. We didn't catch that. Sorry.
Maybe now would be a good time to get to any unanswered questions.
Yeah, I was about to say. All right, one question at the moment. Do you believe that the stimulus funds should be listed on the means test in the excluded non-CMI income section? I guess, I don't know, Patrick, if you want to take that first, what your position would be when you're preparing these, since you're the.
Yeah, I think everybody is well acquainted with how these funds are going to be treated, and I always believe in making sure that your disclosures are as 100% accurate as possible. So I have had some debtors counsel I know out there, they say, well, I'm just ignoring it. I don't know if that's necessarily appropriate. Listing it in Schedule B if it hasn't been received on Chapter 7 cases. That was just a normal, there's an exemption out there, claim the asset and claim the exemption. At this point, the decent majority of people have gotten their stimulus checks. So it's not quite as much of an issue of asset reporting, but then it flips. Is it now something that should be reported as non-CMI? I liken it to just as Social Security. If your client has received Social Security benefits in the 6 months prior to the filing of a bankruptcy, it's a disclosure requirement. It should be listed, even for the purposes of listed as non-CMI. I would find it. You'd have to have a pretty unique fact pattern, I think, for it to create any type of issues at all for you. But I do think that the failure to disclose, does open you to the inquiry of whether your schedules and filing was as accurate as possible. I think that would be my stance.
I don't know, Phil, if you have any input on the stimulus check and the whole means test and how you guys look at it.
Well, I think Patrick brings up a good point. Disclosure of everything, even if it's not relevant, just leads to us having a greater comfort level with your schedules. I am not going to be the first person that stands in front of the court and does anything, with a stimulus check, even for lack of disclosure. But, we work off having good working relationships with the bar, and we work on being able to trust everything that's been filed. So the more you disclose, I think the better off you are to that end. It helps to establish a good working relationship. It helps to show that you're not hiding anything, and it goes a long way towards establishing a level of trust.
Okay. We have another 8 minutes. I mean, we can go over if we need to. But if anybody has any questions, we do have the Q&A box. We'll, I guess, give it a minute if anybody wants to type out any specific questions. Otherwise, we can make some closing remarks and kind of wrap this up. Yeah, depending on what type of device you use, the Q&A box may be the bottom or the top. Just type in the question. I don't necessarily see anything. I think unless you guys have something else to add, I just want to kind of make just a kind of closing summary on all this. Just that from the get-go, we indicated this is a fluid situation that's constantly changing. So some of these things that we implement here may have to be extended, modified, changed over the course of the process. So I guess the thing is always be alert, be cognizant of the notices that the courts send out, make sure to read them, follow them thoroughly. I guess, any feedback, whether it be to any creditors, attorneys, trustees' offices. I mean, we're kind of all navigating this the same, at the same time, and it's unknown for everybody. So nobody's an expert here, and we're trying to do this to accommodate everybody and to do it in the fairest way possible. Actually, we do have a question. No question. We have a question. Where should we list the stimulus money in the petition? I think I'll let Patrick kind of handle that. I think you indicated somewhere on Schedule B, was it?
Yeah, I'd have to check the line offhand, but I usually just toss it into the other section, other asset. I think it's line 22 off the top of my head, but I'm probably wrong since I'm doing it off the top of my head. But it'd be Schedule B, line 20, whatever that is, and just other asset. And I usually just put CARES Act stimulus money and then claim the exemption.
I think there's also a spot, and it goes back to the previous question. I mean, if it was received within the previous 6 months,
sure,
you might want to put it on 22C, again, with the identification that it's CARES Act money so that it's clear that it's not to be counted as part of the disposable income calculation.
And most bankruptcy software out there, would be an other income line on Schedule I that would help populate on the means test as well. Or separately listing, depending on the software you're using out there.
Okay, I don't see any more questions, so I guess we'll start with Phil if you have any kind of closing remarks, and then Patrick, and then we can wrap this up.
Well, two things. First off, never let the perfect be the enemy of the good. When we put these systems and procedures together, we don't know what kind of kinks or bumps we're going to figure out. But it's important to keep moving forward, to have as many procedures in place as possible and to iron out those problems as we go. I mean, if we were to not put anything in place until we figured out every possible permutation, I don't know we would have got anything done. And that same thing goes with your clients as well. I mean, be proactive, get stuff done, make contacts, make those calls. Do things before they become problems. Be proactive is the biggest thing. Also, my mom is pretty impressed that I do a lot of public speaking. So anytime I speak in front of a panel, I usually grab somebody in the front row and ask them to take a picture of me when I'm making some particularly trenchant point. Well, we can't do that right now. So I'm going to ask if everybody will just bear with me for a minute while I take a picture of the Zoom screen. All right. Thank you, everybody. My mom will appreciate it.
I think that's it. I hope this was informative. If you enjoyed it or if you didn't like it, any which way, please give feedback to the CMBA. If it's been a positive experience and we get a lot of positive feedback, maybe we could continue doing these things as this pandemic evolves and our procedures and processes evolve with it. And once again, thank you for attending.